Hello and welcome to Bar 10 Test Prep, Lesson 49. It's our goal to help you prepare for the bar exam, 10 questions at a time. To that end, we upload content on MBE questions on a virtually daily basis. We upload content in general into the channel every day by 8 a.m. Eastern Standard Time. Let's get going with question number 1. Dower, an inexperienced driver, borrowed a car from Pooter, a casual acquaintance, for the express purpose of driving it several blocks to the local drugstore. Instead, Dower drove the car, which then was worth approximately $12,000, 100 miles to other city. While Dower was driving in other city the next day, the car was hit by a negligently driven truck and sustained damage that will cost $3,000 to repair. If repaired, the car will be fully restored to its former condition. If Pooter asserts a claim against Dower based on conversion, Pooter should recover a judgment for A, $12,000, B, $3,000, C, $3,000 plus damages for the loss of the use of the car during its repair, or D, nothing unless Dower was negligent and his negligence was a substantial cause of the collision. Take 10 seconds and choose what you believe to be the best answer now. If you chose option A, $12,000, you're off to a great start and good job. Remember, conversion is the substantial intentional interference with a person's use or possession of chattel. The interference must be so substantial that the defendant should be required to pay the plaintiff in full for the value of the property. The factors used in determining substantial interference are duration, good or bad faith, harm to the property, and inconvenience to the victim. The remedy under conversion is for the defendant to pay the fair market value of the chattel at the time of the conversion of the plaintiff, but the defendant keeps the chattel. In this case, Dower borrowed Pooter's car for the express purpose of driving it several blocks to the local drugstore. Instead, in bad faith, Dower drove the car 100 miles to other city. There is a significant difference between several blocks in the same city versus 100 miles to another city. Pooter was inconvenienced from the possession and use of the car beyond what was agreed upon when Dower drove it to the other city. The harm to the car was in fact approximately $3,000. This is 1/4 of the car's value, which is not a small amount. The elements of conversion, by our point of view, are met, and Dower will be required to pay Pooter's car's fair market value at the time Dower drove the car away, which was $12,000. In turn, Dower keeps the car, therefore Pooter should recover a judgment for $12,000. Key question here, remember that you're being asked or being told that there is a claim for conversion. The moment there's a claim for conversion, obviously the matter was converted or the chattel was converted, meaning the defendant is presumed to take possession of that chattel. So, for example, B would be inappropriate because you could not have the defendant maintain the chattel and then only pay the plaintiff for the damages to the chattel. That would be nonsensical. C, equally, $3,000 plus damages for the loss of the use of the car during its repair. It's not factoring in the fact that under a conversion, the chattel, in fact, has been presumed to be converted, meaning that the defendant has taken possession of that chattel. D, nothing unless Dower was negligent and his negligence was a substantial cause of the collision. Again, inappropriate because ultimately under a theory of conversion, the defendant has in fact converted the property. So B, C, and D would not factor as potential answers because they're not taking into account the fact that the question itself tells you it's an issue of conversion. Question number 2, let's keep up a streak here. In which of the following situations is defendant most likely to be guilty of common law murder? Option A, angered because his neighbor is having a noisy party, defendant fires a rifle into the neighbor's house. The bullet strikes and kills a guest at the party. B, during an argument, Harry slaps defendant. Angered, defendant responds by shooting and killing Harry. C, defendant drives his car through a red light and strikes and kills a pedestrian who is crossing the street. Or D, using his fist, defendant punches Walter in the face. As a result of the blow, Walter falls and hits his head on a concrete curb, suffers a concussion, and dies. Take 10 seconds. And remember, you're being asked which is most likely to be convicted of murder. If you chose option A, you'd be correct. Angered because his neighbor is having a noisy party, defendant fires a rifle into the neighbor's house. The bullet strikes and kills a guest at the party. Remember, second-degree murder or common law murder is the intentional killing of a person with malice aforethought. Malice aforethought exists if there is no excuse justifying the killing, no adequate provocation can be found, and if the killing is committed with one of the following states of mind: an intent to kill, an intent to commit great bodily harm, depraved heart killing, or an intent to commit a felony. A depraved heart killing occurs when the defendant acts with a wanton and willful disregard for human life. Here, the only answer option, which with conduct likely to rise to the level of second-degree murder, is A. Defendant fired a rifle into the neighbor's house because he was angry that his party was extremely noisy. Intentionally firing a rifle into a house during a party indicates a wanton and willful disregard for human life. Defendant very likely knew there was an unjustifiably high risk of someone getting shot and killed, yet defendant chose to proceed anyway. Defendant's actions probably qualify as a depraved heart killing. Accordingly, A provides the situation where a defendant is most likely to be guilty of common law murder. If we look at option B, during an argument, Harry slaps defendant, angered. Defendant responds by shooting and killing Harry. Here, at least, you can arguably say there is some provocation or there is a heated argument. As a result, the possibility of the shooter not thinking correctly is likely greater than in any other situation. Also, one, intent to kill, probably arguably may not be made simply because there is some basis for the response. There is some defense, in essence. Ultimately, C as well, defendant drives his car through a red light and strikes and kills a pedestrian who is crossing the street. Here, there's clearly no intention to commit harm. The intention was really to get through the light, and there obviously was negligence in doing so. But that being said, there was no intent to cause any harm to any other individual. D, using his fist, defendant punches Walter in the face. As a result of the blow, Walter falls and hits his head on the concrete curb. Here, a punch to the face cannot be deemed to be intent or depraved heart killing or intent to commit a felony therein. So none of these potential elements would have been met. And as a result, C and D clearly do not meet the possibility of murder. However, B, during an argument, Harry slaps the defendant. Angered, defendant responds by shooting and killing Harry. Theoretically could meet the standard much more so than C and D. Either way, A is clearly a better answer simply because it explains to you or tells you that the defendant was in fact angered. He had enough time to respond. There was nothing actually in fact happening in front of him. He, on his own, went and chose to pick up a rifle and shoot at the house where the party was coming from. So as a result, A would be the best option. Question number 3. Testator, whose nephew bypassed was his only heir, died leaving a will that gave his entire estate to charity. Bypassed, knowing full well that testator was of sound mind all of his life and having no evidence of the contrary, nevertheless filed a suit contesting testator's will on the ground that testator was incompetent when the will was signed. Craven, testator's executor, offered Bypassed $5,000 to settle the suit, and Bypassed agreed. If Craven then repudiates the agreement and the foregoing facts are proved or admitted in Bypassed suit against Craven for breach of contract, is Bypassed in fact entitled to recover under the prevailing view? A, yes, because the Bypassed Craven agreement was a bargain for exchange. B, yes, because the law encourages the settlement of disputed claims. C, no, because Bypassed did not bring the will contest in good faith. Or D, no, because an agreement to oust the court of its jurisdiction to decide a will contest is contrary to public policy. Take 10 seconds and choose the best option now. If you chose option C, you'd be right and you're on a winning streak here. No, because bypass did not bring the will contest in good faith. A valid contract, remember, requires an offer, acceptance, consideration, and no defenses to formation. Consideration is the bargain for exchange of something of value between the parties. Consideration is present anytime promises with value or performances are exchanged. In addition, the promises must be in fact mutual, with both parties required to perform a detriment in exchange for receiving a benefit. Any legal detriment or forbearance, as well as actual benefits and performance, can constitute consideration. A valid defense to contract formation is the lack of consideration. In this case, bypass filed suit contesting testator's will on the ground that the testator was incompetent when the will was signed. An allegation bypass made in bad faith because bypass knew testator was of sound mind all of his life and bypass had no evidence to the contrary. Craven offered bypass $5,000 to settle the suit and bypass agreed. We see the offer and acceptance, but we do not see valid consideration from both parties. Craven gave valid consideration. The detriment Craven was to perform was giving bypass $5,000, and the benefit Craven would receive was bypass settling the suit. In contrast, bypass only received the benefit of the $5,000, but he performed no detriment of any value. He knew his suit was baseless, but he filed it anyway, in bad faith. Settling this baseless claim was no detriment on his part, and therefore lacks valid consideration. Bypass is not entitled to recover the $5,000 because bypass did not bring the will contest in good faith. If we look at the fact pattern, it tells us that bypass, in fact, did not bring the claim in good faith. It then subsequently says that assume that all of these facts are either proven or admitted in the lawsuit. So if the fact that there was no consideration actually with regards to bypass's position, the court's only position at that point would be to deem the matter invalid and dismiss the case. As a result, C would be the best answer here. Question number 4. National regulation of predatory wild animals on federal lands is most likely A. Constitutional because the protection of wild animals is important to the general welfare. B. Constitutional because Congress has authority to make regulations respecting federal property. C. Unconstitutional because wild animals, as defined by state common law, are not federal property. Or D. Unconstitutional because regulation and control of wild animals is retained by the states under the 10th Amendment. Take 10 seconds, choose your best answer. Yeah. If you chose option B, boy, you're on a roll. Constitutional because Congress has authority to make regulations respecting federal property. The property clause contained in Article 4, Section 3 states that Congress has the power to dispose of and make rules for territories and other properties of the United States. Here, the national regulation of predatory wild animals on federal lands is most likely constitutional because Congress has the power to make rules and regulations for federal properties. Thus, the best answer here is clearly B. If we look at option A, while it is true that the protection of wild animals may be important to some, it is not, without question, an issue of the general welfare. So A would not likely be accurate. C, unconstitutional because wild animals, as defined by state common law, are not federal property. The issue is not whether the animals themselves are federal property, but the land and the land that the animals find themselves on. So C would not be accurate or appropriate. D, unconstitutional because regulation and control of wild animals is retained by the states under the 10th Amendment. Again, here recall the key issue being that the animals are in fact on federal land. So as a result, B is really the only possible answer here. Question number 5. Miller is tried for armed robbery of the First Bank of City. Miller testified on direct examination that he had never been in the First Bank of City. His counsel asked, what, if anything, did you tell the police when you were arrested? If his answer would be, I told him I had never been in the bank, this answer would be A, admissible to prove Miller had never been in the bank. B, admissible as a prior consistent statement. C, inadmissible as hearsay, not within any exception. Or D, inadmissible because it was a self-serving statement by a person with a substantial motive to fabricate. Take 10 seconds. I hope you chose option C, inadmissible as hearsay, not within any exception. Remember, hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that very statement. The hearsay exemptions are admission of a party opponent, vicarious party admissions, and prior statements by a witness. The hearsay exceptions are excited utterance, present sense impressions, present state of mind, statements of past or present mental or physical condition made for medical diagnosis or treatment. Then we have business records exceptions, public records exceptions, and judgments of prior convictions. Here, Miller's attorney asked him to state what he told the police. When Miller then testified, I told him I had never been in the bank. He was offering that out-of-court statement for the truth of the matter asserted in the very statement, i.e. that he had never been in the bank. Miller could obviously testify that he had never been in the bank, but he may not testify that he made the statement to the police because his statement to the police is in fact hearsay. If Miller was accused of changing his story, then the statement might be admissible as a prior consistent statement. As it stands, however, this is hearsay and is in fact inadmissible. However, interestingly enough, if on cross-examination Miller was in fact asked, did he tell the police this? That perhaps may not be a question that would be inadmissible. His answer to that question might be properly admissible because it's simply asking, did he convey the information to the police? Not what information he in fact conveyed to the police. Now, if we look at options A, admissible to prove Miller had never been in the bank, that is the exact basis of why it would be inadmissible because it's actually being presented as proof of the matter asserted within the statement, so that is exactly what makes it hearsay. B, admissible as a prior consistent statement. There would be no need for a prior consistent statement unless he is challenged, so as a result, B would be inappropriate. D, inadmissible because it was a self-serving statement by a person with a substantial motive to fabricate. That is not a basis to exclude any evidence. You will note there are many witnesses that you will see in your career that are fabricating, or that are, in essence, better said, that are presenting self-serving statements with a person who has a substantial motive to fabricate. That, for the most part, is literally every potential witness that is before you, or that is before a court, and potentially also every statement made by every witness could arguably be deemed a definition of D. As a result, C would be the only appropriate answer here. Question number 6. Dealan operates a bank courier service that uses armored trucks to transport money and securities. One of Dealan's armored trucks was parked illegally, too close to a street intersection. Pilcher, driving his car at an excessive speed, skidded into the armored truck while trying to make a turn. The truck was not damaged, but Pilcher was injured. Pilcher has brought an action against Dealan to recover damages for his loss resulting from the accident. The jurisdiction follows a pure comparative negligence rule. In this action, Pilcher should recover A, nothing because Dealan was not an active or efficient cause of Pilcher's loss. B, nothing if Dealan was less negligent than Pilcher. C, his entire loss reduced by a percentage that reflects the negligence attributed to Pilcher. Or D, his entire loss because Dealan's truck suffered no damage. Take 10 seconds and choose what you think is the best answer now. If you chose option C, you'd be correct. His entire loss reduced by a percentage that reflects the negligence attributed to Pilcher. Comparative negligence is the reduction of the plaintiff's recovery by the percentage of fault attributed to the plaintiff. In pure comparative negligence, the plaintiff can recover it no matter how great her comparative negligence is. In this case, Pilcher was driving his car at an excessive speed when he skidded into Dealan's armored truck that was illegally parked too close to the intersection. In this pure comparative negligence jurisdiction, Pilcher's recovery will be reduced by the percentage of fault attributable to Pilcher. Thus, Pilcher should recover his entire loss, reduced by a percentage that reflects the negligence attributable to Pilcher. Question number 7. In an effort to relieve serious and persistent unemployment in the industrialized state of Onondaga, its legislature enacted a statute requiring every business with annual sales in Onondaga of over $1 million to purchase goods and or services in Onondaga equal in value to at least half of the annual sales in Onondaga of the business. Which of the following constitutional provisions is the strongest basis on which to attack this statute? A, the Due Process Clause of the 14th Amendment. B, the Equal Protection Clause. C, the Commerce Clause. Or D, the Privileges and Immunities Clause of the 14th Amendment. Take 10 seconds. Choose your best answer now. The best option is C, the Commerce Clause. If Congress has not acted, a state or local government may regulate local aspects of interstate commerce unless the state or local laws discriminate against out-of-staters or place an undue burden on interstate commerce. This rule is inferred from the grant of power to Congress in the Commerce Clause to regulate interstate commerce. A state or local law that discriminates against out-of-staters is unconstitutional unless the law is necessary to achieve an important governmental purpose. Even if the state or local law is not discriminatory, the law will nevertheless violate the Dormant Commerce Clause if the state or local law places an undue burden on interstate commerce. Here, the Onondaga statute discriminates against out-of-staters by requiring businesses with annual sales in Onondaga of over $1 million to purchase goods and or services in Onondaga equal in value to at least half of the annual sales in Onondaga of the business. Businesses triggering the statute's restriction would be limited in the amount of goods and or services they could purchase from out-of-state businesses. Even if the Onondaga statute was not discriminatory, it still violates the Dormant Commerce Clause because it places an undue burden on interstate commerce by mandating a certain amount of in-state purchases for qualifying businesses. Therefore, the constitutional provision that is the strongest basis on which to attack the Onondaga statute is the Commerce Clause. Question number 8. Miller is tried for armed robbery of the First Bank of City. On cross-examination of Miller, the prosecutor asked Miller whether he was convicted the previous year of tax fraud. This question is A, proper to show that Miller is inclined to lie. B, proper to show that Miller is inclined to steal money. C, improper because the conviction has insufficient similarity to the crime charged. Or D, improper because the probative value of the evidence is outweighed by the danger of unfair prejudice. Take 10 seconds. See if you can choose the best answer now. If you chose option A, proper to show that Miller is inclined to lie, you'd be correct. All convictions for false statements are admissible to impeach a witness. The impeachment by evidence of prior conviction can be made by cross-examination or by record of judgment. The court does not have the power or discretion to balance probative value against unfair prejudice for a crime of lying unless the conviction is over 10 years old. Here, the prosecutor sought to attack Miller's credibility by cross-examining Miller about his prior conviction of tax fraud. Because tax fraud is a crime involving a false statement, it is admissible to impeach this witness. The court does not balance its probative value against unfair prejudice because the conviction is only 1 year old. As such, this question is proper to show that Miller, in fact, is inclined to lie. Now, if we look at option B, proper to show that Miller is inclined to steal money, this would be problematic because you're, in essence, attempting to prove a pattern of behavior and or utilizing this prior incident to show some further guilt on the current incident, which would be inappropriate. C, improper, because the conviction has insufficient similarity to the crime charged. The sufficient similarity is not the issue. The issue is just merely the fact that it was a conviction for a false statement, which as a result is then subsequently admissible to challenge the veracity of the witness on the stand. D, improper because the probative value of the evidence is outweighed by the danger of unfair prejudice. As we just noted, given the fact that this is a false statement, the court does not get to that analysis. And as a result, A is the only correct answer. Question number 9. While walking on a public sidewalk, Anson was struck by a piece of lumber that fell from the roof of Bruce's house. Bruce had hired Chase to make repairs to his roof, and the lumber fell through negligence on Chase's part. If Anson brings an action against Bruce to recover damages for the injury caused by him by Chase's negligence, will Anson in fact prevail? A, yes, under the res ipsa loquitur doctrine. B, yes, if Chase's act was a breach of a non-delegable duty owed by Bruce to Anson. C, no, if Chase was an independent contractor rather than Bruce's servant. Or D, no, if Bruce exercised reasonable care in hiring Chase to do the repair work. Take 10 seconds. Choose your best answer now. If you chose option B, you'd be correct. Yes, if Chase's act was a breach of a non-delegable duty owed by Bruce to Anson. The rule is that if an employee commits a tort in the scope of their employment, the employer will be vicariously liable. As for independent contractors, the general rule is that one who hires an independent contractor is not generally liable for the torts of that independent contractor unless it's a non-delegable duty and or there's an inherently dangerous activity. In this case, Bruce hired Chase to make repairs to his roof. If Chase is an employee, Bruce is vicariously liable for torts committed by Chase in the scope of his employment. It is possible, however, that Chase is not an employee, but rather an independent contractor. If an independent contractor, Bruce would be liable for inherently dangerous activities and non-delegable duties. Therefore, Anson will prevail if Chase's act was a breach of a non-delegable duty owed by Bruce to Anson, given the fact that roofing is not an inherently dangerous activity in and of itself. As a result, B would be the only possible option. Question number 10. Perry sued DiNucci for a libelous letter received by investigator. The authenticity and contents of the letter are disputed. Perry's attorney asked investigator to testify that a week before receiving the libelous letter, he had written to DiNucci inquiring about Perry. The testimony is A, admissible, provided this inquiry was made in the regular course of the investigator's business. B, admissible without production of the inquiry letter or the showing of its unavailability. C, inadmissible unless Perry's attorney has given DiNucci notice of investigator's intended testimony. Or D, inadmissible unless the inquiry letter itself is shown to be unavailable. Take 10 seconds and choose the best answer here. I hope you chose option B, and we're ending on a high note here today. B is the correct answer, admissible without production of the inquiry letter or the showing of its unavailability. Under the best evidence rule, where a witness is testifying as to the contents of a writing and those contents are in fact at issue, the best evidence rule requires that the writing be admitted into evidence unless it has been lost or destroyed, not due to any intentional misconduct of the party seeking to introduce that evidence. Furthermore, the person in possession of the original writing cannot object to its non-production. In this case, Perry's attorney is attempting to introduce testimony by investigator that a week before receiving the libelous letter, investigator had written to DiNucci inquiring about Perry. This means that the original letter inquiring about Perry is in DiNucci's possession, so DiNucci cannot rely on the best evidence rule here. If DiNucci disputes investigator's testimony as to the contents of the inquiry letter, DiNucci can introduce the letter in his possession. Therefore, investigator's testimony is admissible without the production of the inquiry letter or the showing of its unavailability. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content.